Hello, Council. Today, we're discussing an important shift in arbitration, documents-only proceedings. While in-person hearings and oral advocacy remain central to many cases, some institutions are offering documents-only arbitration as an option in certain cases. For many lawyers trained in common law systems, this idea may seem unfamiliar, even uncomfortable. In common law practice, oral argument is often seen as the primary opportunity to present the case. However, in civil law jurisdictions where cases are largely decided on written submissions, documents-only proceedings feel much more natural. This difference in legal traditions raises an important question. What does opportunity to present really mean? In a documents-only arbitration, the tribunal decides the case based solely on written submissions, documentary evidence, and expert reports. There are no oral arguments, witness examinations, or live cross-examinations. This approach is typically used in cases where the facts are clear and undisputed. The dispute involves contract interpretation or issues that don't require witness testimony. The cost and time of an oral hearing outweighs its benefits. For many arbitration institutions, documents-only proceedings are viewed as a way to increase efficiency and reduce cost. By removing the logistical burdens of scheduling hearings and coordinating multiple parties across jurisdictions, the process becomes faster and more accessible. One of the biggest concerns about documents-only arbitration is whether it limits a party's ability to present their case. However, what it means to present the case depends heavily on legal tradition. In common law system, oral hearings are fundamental. Lawyers expect to argue their case in front of a tribunal, respond to questions in real time, and challenge a witness through cross-examination. Many common law trained practitioners view oral advocacy as an essential component of procedural fairness. In contrast, civil law systems rely more on written advocacy. The tribunal plays a more active role in reviewing submissions and questioning the parties, often without the need for extensive oral hearings. From this perspective, the opportunity to present the case means the opportunity to submit well-structured, persuasive written arguments rather than engaging in oral debate. This difference in expectations is why some common law lawyers resist documents-only proceedings, feeling that arbitration without an oral hearing limits due process. Civil law trained practitioners, however, may see it as simply a more streamlined and efficient way to resolve disputes. Beyond legal traditions, documents-only arbitration also raised another key issue: language barriers. For many lawyers in Korea, Japan, China, and other non-English speaking civil law jurisdictions, oral hearing can feel like an inherent disadvantage. International arbitration is often conducted in English, placing non-native speakers at a linguistic disadvantage when engaging in live advocacy. Cross-examination, in particular, can be challenging as it requires quick thinking, precise responses, and control over complex legal arguments in a second language. From this perspective, documents-only arbitration levels the playing field. It allows all parties, regardless of their language ability, to present their strongest argument in writing, ensuring that cases are decided based on the quality of legal reasoning rather than fluency in oral advocacy. Although arbitration is designed to be flexible and adaptable, many procedural rules and practices still reflect common law influences. The emphasis on oral argument, cross-examination, and adversarial hearing remains strong. However, some arbitration institutions are offering documents-only arbitration as an option in certain cases, encouraging parties to consider whether an oral hearing is truly necessary. In cases where live testimony adds little value, documents-only arbitration offers a practical and cost-effective alternative. This shift doesn't mean that oral hearings will disappear. Instead, it reflects a growing recognition that arbitration should adapt to different legal traditions and that written advocacy can be just as powerful as oral argument in many cases. The move toward documents-only arbitration is pushing practitioners to rethink long-standing assumptions about what it means to present a case. While oral advocacy will always have a place in arbitration, not every case requires it. Rather than resisting this shift, we should see it as an opportunity to make arbitration more flexible, efficient, and inclusive. By embracing different approaches, we can ensure that arbitration remains a truly global system, accommodating both common law and civil law tradition. Well, that's it for today. Until next time, sharpen your ADR skills and elevate your practice.